Ready? All right, everyone. Let's I had the gavel. Or call it to order.
It's crazy.
It is 6:02, so I'm going to go ahead and call our August 19th Charter Review Committee meeting to order. First up on our agenda is public comments. Do we have anyone to share public comments with us today? Hearing none, I'll move over to item C, regular agenda items. Now, before I get started, I do want to go through your packet so you kind of know what's in there. And so first, and it's separated by each section. So you have C1, 2, 3, 4, 5. So C1, you have the minutes. C2, you'll actually have the list of the recommendations. I'm sorry, C2, you have the items that we requested the city attorney for review. So I'll turn it over to him. C3, you have the items for final recommendations that came out of our discussion from last time in section 7 of the charter. And then C4, we'll discuss articles 8 and 9, and articles 8 and 9 are in your packet, so you can refer to them in real time. And then C5 will be any other item for review. Now, there may be items for review during the discussion, which we can also take into account during that time. But I just wanted to go through all of the items in there because we did add a couple of things just to make it easier for our community members. We're living and we're learning and we're making things better. So just wanted to go over that before we actually go through the regular agenda items. So having said that, item C1 is consider approval of the minutes of the July 15, 2026 Charter Review Committee meeting and take appropriate action. The minutes are in your packet. Do I have a motion to approve the minutes?
I make a motion to approve the minutes.
Motion, I'll second. Any discussion? All in favor, say aye. Oh,
Aye.
wait, discussion, just kidding.
Can I just draw attention to page 5? The meeting adjourned at 7:78 a.m.
I was gonna say that.
Oh, sorry.
Yeah.
Did I go too quickly, Polly? Sorry.
Okay.
Patrick.
Sure, 7:58. Pretty sure 7:58.
What is it supposed to be, 30? It
I
was-
think it's supposed to be 15. Can we confirm that?
We'll confirm.
Okay, so we're gonna move item C1 to the end of the agenda. So that way we can confirm the time that our committee ended. So that way we still take care of the minutes today. If that's okay with our city secretary. Great catch, great catch. Okay, item C2, discuss and consider items requested for review by the city attorney. So I'm going to go ahead and turn it over to the other David.
Something big?
Yeah,
We got 3. Yeah.
I know.
I know.
Dave B. Oh, wait, there's 2.
So in the agenda packet, under item C4, we left last time with 7 items of homework for me. Thank you very much. And in the packet are responses. And let's go over them pretty quickly. First is the transit committee issue dealing with section 8.13 of the charter. I proposed the first set of words, the first language. And we talked at the last meeting about the alternative provision that Mr. Pelican submitted and proposed. We had some handwritten notes on a redraft. I incorporated those notes, and that is in the second section under alternate provision. So with that, I mean, those are the 2 different proposals that are on the table. You guys discuss and figure out which one you want to recommend, if you want to recommend them at all. And I'm going to do that now, or just wait until.
We'll wait until the, yeah, we'll wait until we go through the list.
All right, so the second was the concept of adding an at-large member. Now it's a bit more problematic.
It's on page 8, proposed language, the bottom right hand corner.
Yeah, we'll probably be able to know that we have access to this, looking at it.
Yeah, so all of
I don't know, it's
the,
helpful sometimes.
yeah, all of the items that our city attorney is talking about in Q2 are in your packet right after that section.
Got it? I got it. You guys will be talking about this in a while. Okay. Second task was dealing with the concept of adding an at-large member to council. Concept, as you recall, we only have 5-member council, council mayor, 6-member council, mayor, and 5 council members, each in specific voting districts, other than the mayor, who's the only one elected at large. We talked about the Voting Rights Act and the changes in that body of law over the past 20 years or so. We are not uncomfortable with proposing the addition of an at-large district with one other council member who would be elected at large. Never any guarantees, but the thought is that at this point, would probably be okay if we did it, but there are never any guarantees. If we wanted to propose that, the language that would be revised would be in section 2.01. In your agenda packet, I've underlined wording that would be added. To cascade that change would necessarily involve tweaks, really minor non-substantive revisions to section 7.03, 7.04, and 7.10. The true language, really the operative language in section is in section 2.01. The council shall consist of 7, striking through 6, and 6, striking through 5 council members. The mayor and 1 council member for District 6 would be elected by the voters at large. The remaining 5 council members would be elected based on the specific districts in which they reside. The other changes are literally tweaks that conform succeeding cascading sections to comply with or to match the language of having a new District 6 and 5 or 6 council members plus land. That makes sense. And that is something that, you guys need to figure out if you want to consider doing that and would make that recommendation to council. I believe that these are the changes that would necessarily be involved in order for the charge to be amended to change the structure of it. The next category was Articles 2 and 7.5 fire terms and term limits. It is simply an addition in section 7.04 subsection B, adding subpart 4. My recollection was that we did not come up with a firm conclusion on this, and it was kind of left to me to make it up in a law. The language that I proposed would be to add that subpart that said nothing more than it starts in the office of mayor or council member for a period of at least 2 years shall be deemed service for a full term. I'm not pulling that out of a hat and making it up as I go along. For cities that have terms of office that exceeds 2 years, there is a watershed at the 2-year mark. So that if, for example, there were a vacancy in the office of a council member, and there was a period of less than, or a term of less than 1 year remaining in that council member term of office, then a special election need not be called. For a term where there's more than 1 year left in a term, then cities are required to call for a special election. So basically using that as a pattern, I just basically came up with a provision that indicates that a partial term is a full term if there is at least, if they have served at least 2 years in office. That makes sense? Yeah.
So we're gonna be
For not.
voting over these?
Honestly, so I think because we asked some homework, I still think now that we have the information and the opportunity to talk to the city attorney, I don't think it's enough time for us during this meeting to actually vote on these, and I want to give you all time to review. It's a lot. So my recommendation is for him to go through them, ask any questions at this time that you have, and then we bring this back and add these to the list of items for consideration for vote for our September meeting. That's my recommendation because it is a lot. We did give you a lot of homework.
Thank you.
And I want this time for us to be able to ask any questions we may have, so we all have all of the information and we can then go back and think about it a little bit. So that's my recommendation, and we can talk more about it after he has gone through all of the sections.
Does that make sense?
That's it.
Okay.
Somebody will read it.
Yeah, I gotta say, we're coming up, we're getting down to the wire here, so. These are drafted in a format that you can simply approve approve,
Mhm.
or,
Or-
or if you needed to tweak, but they're in more or less final form.
Mhm.
The next three consecutive,
My question for that, for three, with the service period of at least 2 years shall be deemed full term, there aren't any, consequential areas within the charter that we also need to amend?
oh, you mean other cascading
Yeah.
changes? I didn't see any. I don't
Okay,
think so.
okay, I just wanna make
think
sure.
that's pretty straightforward.
Yeah, okay.
The next three items, item number 4, item number 5, and item number 6, all deal with the city attorney. I'm not really completely comfortable with doing this because it's clearly in my own, I shouldn't say that because really it's not. But me as a city attorney drafting provisions that respect the city attorney are a bit unusual. But first and foremost, I think that where it identifies the section in the charter as 3.08, I think it should be 3.07. That may be a typo or modifier. I was able to find one other typo in this document, and it was an end quotes. And you can look, you'll never find it, I swear. But maybe somebody will find it. Maybe, you can bug it. Somebody will find it. All right, so here's the deal. Number 1, subsection A of the proposed charter amendment. The city council shall appoint a competent, duly qualified, licensed and practicing attorney in the state of Texas who shall serve as the city attorney. That's generic language, and that's pulled from a whole bunch of different city charters. The council, including the mayor, who shall have the right to vote, the affirmative vote of 4 members, remove the city attorney from office. I'm not making that up. The instruction that I had, or the conversations that we had quite some time ago, was to make it similar to the city manager, and that language is verbatim language from the charter dealing with the city manager, except it says city attorney as for the city manager. Keep in mind that if we talk about, and a charter amendment is approved that increases the size of the council from 6 to 7, 4 is a simple majority and not a super majority. I talked about it at the city manager. That makes sense. Y'all get that?
No.
Okay. So, but I didn't put that in there because I really, really like it, even though I do. That language comes from our conversation where the suggestion was to pattern it after the city manager. Subsection B, kind of generic language. And in looking at comparable provisions in other city charters, it just outlines the duties in broad terms. Represent the city in litigation and legal proceedings as directed by council, provide opinions, draft contracts, resolutions, things like that, and serve as a legal advisor to the officers of their departments and perform such duties as may be imposed by law. The last sentence, the council may adopt such rules as it may deem appropriate regarding requests for legal assistance and the delegation of rights to individual members of the council is something that we had also talked about, I believe, the last meeting. I will say this. There is currently in the council's rules of procedure a provision that rather than putting it in the charter, my thought is it's best left to the discretion of the council because it's more of an operational kind of thing. I mean, you can recommend a charter provision, but the nature of that type of provision is really more or less a rule of procedure. And there is currently a provision in the existing rules of procedure that do talk about that. And so you may or may not want to have that section or that sentence in there at all. You can if you want. If you leave it out, then by default, it will default to rules of procedure. Having it in the charter is kind of a reminder or direction to the council to find the voters who approve it, but at least consider and adopt some kind of subdivision.
Talk about section D.
Yeah, it's the last,
Section B.
it's the last section. It's a section B. And just a reminder, this kind of came about because one of the things that was discussed was using the city attorney for or requesting assistance from the city attorney on things that there may be some gray area, or maybe something that's a little more personal, where it shouldn't be the city attorney being the one to advise the council member. It should be the council member getting their own legal counsel for certain things that are occurring. And so, there is a procedure where there are procedures where the council can go ahead and develop their own kind of rules to ensure that the use of city council member of the city attorney is appropriate. But there was discussion of us adding a provision in the charter to ensure that we remind our council members that, you know, there are certain things that they can and cannot utilize the city attorney for. However, they still have to be in the procedures under the mayor city council procedures. There's some language in there. So it's kind of like doing it twice. But again, we did discuss it with the city attorney. We did ask him to create some language. So that'll be up to us to decide what, one, we want to add language B of section 307, and two, if you want to add that last sentence to that section. So
Quick question. If we were to add something like that, could they undo it by a vote amongst themselves, or would that stop them from ever eliminating? Because if you have a split council or there's a fraction, right, and then they come up with some absurd rule, this would be, that would supersede all their rules, correct?
Well, the charter provision that is in fact the recommended charter provision just simply directs them to adopt a rule. If they fail to adopt a rule, we understand that the charter provisions are really kind of mandates by the voters that set the structure of our government. If the voters mandate that the council adopt a rule and the council refuses to do it.
So right now, it's more like they shall, this would make it, they must,
And they can't undo it.
and they can.
So that's like the essence.
Yeah, I know. Now they still have to decide what they do, and they're gonna have to come into consensus to do it. But this mandates that they have to come up with some language in the procedures to ensure that the utilization of the city attorney is appropriate. and ethical. And so I think there's, you know, that's the difference, right? Right now they can, because it's in the procedures, this would make it to where they must create a rule to add to the procedures, so that way they ensure that they're using the attorney appropriately.
Which
That makes sense.
Why not just make a rule?
Yeah. No, yeah, exactly.
Yeah, why
No.
not make the rule?
I'm sorry, I'm slow.
But the rule is.
We're gonna force you to make a rule.
I know, so.
Yeah.
I'll tell you why.
What does that do?
Well, let me tell you why I think that it's not the rule in the charter.
So it says it in the area before.
The rule, the council rules of procedure that they adopted, number of months ago. It's a paragraph long and it's complicated. In order for us to put it in the charter, it would be really awkward and unwieldy. I can read it to you if you want, but you can ask, council members can ask, at any time, make a request on the city attorney to advise on legal matters. It can include questions regarding personal conflicts of interest that are related to city business. Request for formal legal opinions or advice from the city attorney made outside of the meeting must be submitted to the city manager unless the subject matter, blah, blah, blah. Okay? So you see what I'm saying? I mean, in charter provision, the goal is really for it to be organic and flexible.
Yeah.
The more vague it is, the better off it is, because then we can interpret it as we go along. Put something like this in the charter provisions. But. All right, in subsection C of 3.07, the city attorney may, but this was the dichotomy between using outside counsel versus in-house. And the charter provision that would authorize or enable the use of in-house counsel. I don't think that having nothing about it in the charter at all precludes the council from doing that if they wanted to. But, you know, in coming up with language that might work, you know, what I wrote was the city attorney may but need not be an employee of the city, meaning that they could use outside counsel or use in-house counsel. The city council may employ an in-house city attorney and retain the services of outside counsel, each of whom shall have the duties as may be determined by the council. The section shall not be construed to prevent the council from appointing a special counsel department to the attorney to provide legal assistance on specific matters. All cities use special counsel on specific things, like bond counsel, for example, two bonds and something, special counsel. So you guys can recommend that as a charter proposition. You may, but you need not. That you guys figure out. Okay, and then the last item of homework, I thank you for all that. It wasn't that I was tired when I got to the seven. It was just that the talk was to review definitions used throughout the charter and advise whether provisions, additions, or consolidation of defined terms are appropriate, and I couldn't find any definitions in the charter. And not that there aren't any, but I looked at that there's nothing. I mean, comprehensive codes, zoning ordinances, for example, comprehensive zoning ordinances will begin with a list of definitions. You know, animal control regulations begin with a list of definitions. You'll never see that in charter, so. And our charter does not have a specific section that defines any of the terms that are used. I'm speculating, but maybe the reason why is because although, you know, the basic rule of construction is that when you're interpreting a statute or charter provision, you look at the plain and ordinary meaning of the words that are used. And sometimes you refer to the dictionary because courts often do that. But if terms have words of art, some specific usage, that's what really needs to be defined. We don't really. Charter is a living, breathing, organic document that stays like it is. It can be amended with some difficulty, but it's subject to different interpretations. So you put definitions in if you want to, but the more you put in there, the less flexible the charter becomes going down the road. That makes sense.
Well, most constitutions don't have definition.
The US Constitution doesn't have any. It doesn't have any. God forbid, can you imagine? I mean, because they had definitions from 200 years ago, that would work right now. So you can add definitions if you want. I just didn't see any need to put any in anywhere because all the terms are really written in fairly straightforward language. And if you didn't understand the term, then any court would first off open up the dictionary and look at that. So I mean, I've actually used the dictionaries in Supreme Court arguments before, you know.
No, thank you. So it looks like based on what we reviewed or what the attorney has reviewed with us, 1, 2, 3, 4, 5, and 6 under section C2 are things that we would come back for consideration. And item 7, the findings are that there are none. So, or that there are no definitions, so we won't need to take action on that. And so my recommendation, like I mentioned earlier, is for us to bring these items back and add them to the next agenda item for September under the item where we discuss and consider or when we consider proposed amendments for final recommendation. And we go through each one and vote on them just like we do. Are there any questions about, I know we were kind of taking questions during each one, but are any final questions or thoughts before we move forward with onto section C3? So 1, 2, 3, 4, 5, and 6. So basically the only one that we won't consider was number 7. Under C2.
What I'm gonna suggest, then you guys should be prepared at the next meeting to make a motion. I move that we approve
vote.
The following division.
Yeah, if there are revisions for them. And so one thing that we do need to be mindful of is for the cascading provisions that need to be changed, if we change, you know, one of the areas of the charter, specifically for number 2.
I mean,
Yeah.
should we take a straw vote just to see where we are? Because, I mean, we're going far down the rabbit hole. Looks fine. If not many people are there, why would we waste any more?
Yeah, that makes sense.
As far as, for consideration.
See if
That's a good idea.
If anything is up for. I mean, it's not.
Yeah, I don't know. Yeah, we can add some questions.
It's not a pending, I mean, it's not a vote that was going to actually count. It's just,
No, this one's like a straw poll. Like, it's kind of like what we did last time where we did a straw poll about oh my gosh, what was it?
May.
About the May and November.
May, November
We took a straw poll. Most of us didn't want to consider it, so we didn't even, and if we're kind of in the middle, then we should go back and consider it. So I think we do something similar to what we did last meeting, but Dave, you had questions?
Yeah.
Should have asked it previously, sir. Just kidding.
So on. Covered, I have a note about the cascading stuff. If we
change the numbers. How are we gonna do it? When are we gonna do it? Mayor does vote. Three votes. So I think you're cascading is where, if anywhere in the charter where it talks about the number of votes.
They put them on here.
We're
yeah.
we're gonna be there.
Yeah, so the sections that need to calculate are in the packet. Yeah.
Everyone's in their car.
Everyone's in there,
So
yeah.
with the quorum definitions and all that, okay.
Crystal, you said that everything that we, even if we vote to do something, the council has to
The
approve.
council has to approve it. So basically, we've taken some straw votes, which are not official. They're not going, but the ones that we do, basically, we are going to, there's gonna be an item on the city council agenda where I'm going to present all the different, potential changes that we want to make to charter, and the city council is going to have to approve or move forward with or vote down our recommendations.
Right. You know, we've kicked a lot of stuff right back to that council, and if anybody's been watching this stuff around here, I think we need to at least give them a black and white issue. The more that we keep giving them the ability to run, you know, some of the nonsense that's going on up there, I just think that we need to consider giving them resolute things like this guy said, you must do this. Well, they can vote it out, but we
Yeah.
need to have, I think we need to have some more rules on the ethics and not anything about the other day. I'm not talking about that, but there needs to be more black and white rules that this charter committee sending up to them and they can vote it yes or no, because we've just, seems like everything that was tough, we say, well, let's let them manage themselves. Well, it looks to me like they're struggling to manage themselves.
Yeah, and I think.
That could just be maybe
No,
I'm wrong opinion.
Most part, I will say, because I'm very proud of the work that we've done, that we've actually had some pretty great, good discussions on things. Most of the stuff that we've, kind of advised not to add to charter is because it's a procedure. Or it's maybe on part of planning and zoning, and so it's not really germane to the charter. And we don't want to also set a precedent where every single little thing we mandate. But the example that we gave today for, as an example, is a good opportunity for, it's like, well, we need to have them do it. Because obviously there's been some input where council members have, potentially used city attorney for other purposes that are a little gray. And so that would be one where, and one of the questions that I had was under, and I think you also mentioned it, Coke, is like for section 307B, it still says the council may adopt such rules, and like they should adopt such rules.
Yes.
Right? And so, instead of may, it should be should, and so, or shall, shall. No, actually, yeah.
Yeah.
Or must, but anyway, so.
I shall be.
I don't think that-
Yeah, but when it comes to law, that's a very important
You
word.
know what, Chase? I'm gonna let Chase select the verbiage.
I don't get paid.
Neither
Run
do
my
I.
tape.
Neither do I.
You
And I'm
volunteered,
not-
you're our leader.
Actually, you all volunteered to be here. So,
I've
no,
done
but I'm
it.
kidding.
So, but Todd, you're.
See, Chase?
What you're saying, Todd, is yes, I think we all see that the council at the moment is sometimes dysfunctional. Cause sometimes, I'm being generous.
Yeah,
Good. But that mean, they do get things done. It's just, there's more work involved right now just because they're not all getting along. That's not a common theme over the years. So I think while we're in a point, when we're in a rough patch, I think we get beyond this. And so if we try, at this one point to micromanage, it's, as much as we'd like to be able to all sit down with them, say, hey, guys, can we be grown-ups?
That's not gonna happen.
No, because we don't have any authority with it.
Right.
But you're right, this is an opportunity to put teeth into some things that maybe
Yeah.
don't have any teeth, and so I think we do need to take that into consideration as we're finishing out our term. We only have a couple more meetings to ensure that, and we'll probably go over all of the things we will go over all of the items that we actually voted on to go through. And so that'll really be our last opportunity for us to make any changes or additions, so,
Okay.
yeah,
All right, so back to the things I had.
go ahead. Kevin?
Before we go to that, if you don't mind, I'll take the opposite position of that. I think in opportunities where the council needs the most adult focused energy in the room is the exact moment when it'll never happen. So I'm a firm believer in putting some guardrails up. I don't know how many of you and your families leave it up to the kids to come up with a resolution on issues that are going on in the back seat. Because believe me, when there's issues in the back seat, They aren't logical. They're not thinking right. They're probably not feeling well. So I'm of the opinion we need more guardrails. And I'll give you a perfect example. The other night was one where we had an outside attorney, and we probably need additional language there. Come into city council meeting without our city attorney knowing anything about it. And the fiasco that transpired really makes us look foolish as a city.
Are you talking about Omar? Omar's not an attorney. Is that who you're?
No. It was another lawyer.
Oh, okay.
No, it was the ethics attorney that was
Oh, okay.
hired to share the review of what transpired, and they were able to get
This is a
videos.
public meeting though, right? So like, it's probably not a space in which we should go through this.
Yeah, no, I think he was just saying the example of, there was an outside attorney and that maybe there should be language as it relates to any outside counsel to ensure that certain people probably have the information as to what they're reviewing. I'm assuming is that what you're
Yes,
talking about?
so when the decision-making falls apart, there's default rules in place, so we don't go into chaos.
So Kevin, I think I have a little idea what you're talking about, but a lot of folks in here may not really know enough of the details for them to, the context or to sink in and make sense. So as much as I hate to have us be too specific, I think we need to be a little more specific, or if you would be more specific about this attorney and the issue, unless everybody feels like they know what went on and who this attorney was and what was at issue.
I was long asleep.
Yeah.
When I heard 28 witnesses, I was like, click. That's it.
That's, when you said attorney, that's kind of who I thought. So Kevin, I'm not sure the other attorney that you're referring to. So either Dave or Kevin, can you kind of enlighten us? If everybody cares, I mean, if you don't care, I don't need to be educated.
Well,
Dave, for Open Meetings Act, I'll let you.
the council direct staff to retain the services of an individual named George Hyde, with the firm out of Austin to step in and provide you with specific legal advice pertaining to the ethics process. We conducted an executive session, gave a presentation, and he attended the balance of the council meeting, and it was a long. But he was retained by staff and by the council for a very specific issue. And so,
And that, to my understanding, is not abnormal, right? Because there are certain attorneys, kind of like you have a very specific niche as it relates to city government, as opposed to maybe someone that does criminal law and all these other things, correct? Correct me if I'm wrong, I'm not sure.
it's just that if the council wants a second opinion, any doctor would encourage you to get a second opinion. It doesn't hurt my feelings, and I think it's probably a good idea. I don't necessarily agree with the second opinion, but I mean,
Got it.
I don't really see that what they did was, although mechanically it probably would have been different if I would have went in Nazi. I think the concept of defidal was not unsound, if that makes any sense. For lack of a better expression, it was not unsound.
The fact that they acquired a second opinion is not unsound, although the discussion really is the findings, right? But that's up to the attorney that they've hired.
I believe the issue was there was not prior collaboration with the entire council. And, including our city attorney.
Yeah, it hurt my
So everybody was kind of blindsided. Well, not everybody. There were certain members of the council that, wanted it on the consent agenda. But then they pulled it out and required that it be heard, but no one really had prior knowledge of it before the. So,
There was no notice.
No notice.
Participation in decision process.
and I'm thinking if you go out, like in any corporate structure, if you go out and you solicit services that are gonna cost money, you should have a requisition process in place, where at least the council can vote on it.
Well,
Kevin, how much said $50,000?
what?
They spent $50,000 on this.
Yeah.
We told the attorney firm you can spend up to 50 grand.
And so they did.
Well, they will.
They will.
No, I don't
No, they did.
I don't think they spent 50 grand already. I don't know, but I don't think they did.
And they didn't count the 5 hours that you got that night either.
Yeah, no, it was only 5.
Well, I mean, extra 5 hours.
That meeting, I was starting to finish was 11. But there may be some solution to that concern. As it stands right now, our charter contains no provisions that deal with the appointment of the city attorney. It says very little at all, if anything, that deals with the city attorney. So, you know, one of the propositions that you guys are considering is a provision that says that the council shall appoint city attorney. By default, because the charter doesn't contain provisions, the general thought is that technically the city manager, because the charter doesn't delegate that responsibility to the council, the city manager can hire a city attorney. And he's got discretionary spending authority of between $50,000 to $100,000. And so, procedurally, the way that it has been done historically, I shouldn't say historically, but for the past, I guess, the past 3 rounds or 2 rounds, the city manager will act under the direction of the council because that's who he responds to. Although in theory, under the charter and our ordinances, he could hire a lawyer if he wanted to represent the city because there's no prohibition. One of the charter propositions that we are considering is one that says the council shall appoint the city attorney, which means that the city manager wouldn't be able to do it. Now, there might still be an end round under our existing structure of government down the road, but
You made it into round.
well,
Explain.
as it stands right now, a quorum is 4, a majority vote is 3. And so, 3 council members could ensure that a specific individual were hired as the city attorney or as a special counsel. If it were an item that required formal council action, the city attorney would be if the charter provision were adopted, then during the meeting, 3 council members, one would make a vote, or one would make a motion, and one would make a second. That's a majority vote.
So if we adopt section A, where it says city council shall appoint on the city attorney, then what occurred during that meeting wouldn't happen because the city council are the ones that have to appoint that attorney, even if it's an outside council or a subject matter expert, right?
Problem without us having to go down another one.
Yeah.
So the other part is looking at 3.8 and what dovetailing what you're saying is you have a supermajority voting to remove, but you don't have a supermajority voting to appoint. And I think that under the city manager provision, don't we, it doesn't require a supermajority to hire a city manager or not.
I don't think that, I think they just hire 6.
So three can hire, but.
I'm sorry, let me I'll read it to you, so the council, including the mayor, who shall have the right to vote upon the affirmative vote of 4 council members, which may include the mayor shall appoint the city manager for the term. So yeah, as far as, so.
That's one of the notes I had is that we should consider whether if it takes 4 to fire, do we need 4 to hire? I mean, we're talking about the head of the city, the guy doing most work, and we want to make sure that we got enough people that are blessing the hire, on this one. My thought is in the past, that's where we want done it with the city manager, or why we would do it with the city attorney, but maybe the city attorney, I mean, city attorney is a huge position. So,
I mean, functionally, is it easy to have people apply? Is that like a difficult job to hire? Because I mean, if you have someone Pickens, you can't get people to agree.
that could be a problem.
Yeah, that one wouldn't be.
I don't know if anybody's here that can tell us when your firm got hired, David. How many different firms applied? I don't know.
My office was hired, excuse me, initially in 2018, 2017, somewhere in the timeframe, late teens, around that one.
Yeah.
There were 4 other firms that 3 or 4 that submitted applications, submitted proposals. When the city went out for RFP in 2024, I don't know how many responses were submitted, but I think it's 3.
Y'all were one of those?
Yeah.
Okay.
There aren't, if you include me, it would have been 4. There aren't many firms that do this kind of work. I know there are individual lawyers that might consider it for small towns, but by and large, the set of law firms that specialize in municipal law in this region. There's, yeah, which is kind of good because there's not much competition. But it's kind of bad because it's fierce competition.
I would be okay with, I mean, we can talk more about that, but leaving the simple majority for that very reason.
Yeah, the process of firing your city attorney could create all kinds of havoc, so I'm good with the supermajority, so you're gonna have to convince a lot of people.
Yeah,
It
makes sense.
Just because of the sheer turmoil, if you said, hey, tomorrow, David, y'all pack up and go. The city manager doesn't have the capabilities to run it. Hiring an in-house attorney would be tired and time consuming in and of itself, and then getting them up to speed would be, a problem. So I think we need to stick with 4 to fire or supermajority if we're gonna go with the single member district and the at large. Probably need to tweak that language, but it
Well, it says 4 on here, right?
says 4, but
For the simple majority.
and then if we did go up to 7 council members, supermajority is now 5 by definition.
So, if you,
Are you saying super or simple?
super.
It's East Texas that I don't.
I didn't mean to take us off on a tangent.
No, it's
But
good stuff.
that's a perfect example.
A
of
good
guardrails.
tangent. No, yeah.
Because when things implode, fighting in the backseat, we've got to have some guardrails that continue to manage through that process.
My dad just used a belt.
Grew up in the 60s, didn't you?
So we're gonna do a straw poll for this one anyways, and then once we do, when we get back, we can have that discussion. We still have to go through 2 articles as well. Kevin, I know you had a question. Did we answer your question?
I move we bring back the belt.
Add that to the minutes. Okay, any other questions before we move on?
Yeah, on B, city attorney shall serve as the legal advisor of the city council. I just wondered if, I guess it's kind of tied back into, there needs to be limits on which one are guardrails or belts. Kevin, or David, are you comfortable leaving it without any restrictions?
But it says it on here, like it says contracts, legal instruments, ordinances, resolutions. So it kind of already has that to where,
Well, it's just
So, but-
litigation and legal.
No, my original-
Council review, so I just,
my original draft didn't have any duties at all. I mean, there, the position of city attorney implies a whole range of different functions. Some cities outline and some cities don't say anything at all.
Right.
But some cities have just general terms that are kind of like this. I just kind of put that in there.
Well, that's kind of leads to my next question is, you do have a laundry list of things, but when I look at it, I think, okay, review and provide opinions as requested by the city council on contracts, for instance. That doesn't include drafting, and there's a lot of contracts that need to be drafted, so, so it's, to me, if I'm being really nitpicky and I was fighting something, I'd say, it doesn't give the city attorneys the right to draft a contract, so I think you need a little broader, something along legal services.
But I think you're reading it restrictively as opposed to, permissively. Because it's not specified in there, doesn't mean that that duty doesn't exist.
Yeah.
And there needs to be vague to make it flexible, I guess.
I hear you. I think if you use the term services or opinions, services is very broad and permissive.
Right.
Whereas opinions, as requested, review and provide opinions, that's pretty narrow. I just think that maybe adding services now gives it more flexibility and permissive, is the reason I wrote services on my paper. Just give it a little more clarity that it's not really narrowly tailored to just reviewing and opining. That you follow me?
Yeah.
Okay.
I'm okay with that. I mean, like I said, I've been shot my initial draft didn't have any, right, didn't specify duties at all. Just sort of, any way you want.
Okay, and then it talks about the city council. I'm wondering whether we add in a provision. Under first sentence, city attorney shall serve as legal advisor, city council represents city in litigation and legal proceedings as directed by the city council. I'm just throwing this out there for thought, or as delegated by council to the city manager, unless you think that's already applied.
Go back, start over again.
First sentence
Of subsection C,
of B,
of B,
and right after on the second line, right after student council near the end. This is called what city attorney can do for the city council, as directed by city council or as delegated by council to the city manager,
as requested by the city council.
as delegated by the city. Sorry,
Or as the, so let me type in.
Okay,
sorry,
I need to
I'm big, yeah.
wrap my head around. Well, we're not voting on the language, we're only doing a straw poll, but just.
But we're not straw polling this part, right? Is this what we're gonna talk about next time?
So, but if we're going to straw poll, it could be either one. It could be, I could back away on this or have this in so we know where the potential pitfalls are, or
Okay.
tweaks.
Okay, I got you.
But I also know that we have do have limitations on time. Anyway, are you ready, David?
Yeah, hang on a second, I'm gonna say that before I either.
City attorney shall serve as the legal advisor to the city council, represents the city in litigation and legal proceedings as directed by the city council or
Just delegate.
as delegated by the city council to the city manager.
Well, I'll read you the language. Perfect. But beginning with the first line, so the city attorney shall serve as legal advisor. The city council, represent the city of litigation and legal proceedings as directed by the city council, or review and provide opinions as requested by the city council, or as delegated by the council to the city manager.
And I think you want that after city council. So directed by the city council or right here. Directed by the city council.
Directed by the city council, right, yeah, start out with down there with the.
Yeah,
That made less sense,
no, he has it in the right section, he just needs the language.
Oh, you're,
Yeah, read what you wanted to say, I mean,
All right, so are you at the comma?
Yes,
the city attorney shall serve as a legal advisor of the city council, represent the city in litigation and legal proceedings as directed by the city council.
Or as delegated by the city council to the city manager. I don't.
and just so everybody kind of understands, can you give an example of what that would mean? Just so everybody's,
So because the city manager is dealing more directly with the city attorney normally, or vice versa, the city council should delegate or can delegate to the city manager, hey, you're gonna have the daily interaction with the attorneys. You deal with the contracts, you decide, you hire them to hire these contracts for these projects. And then they come back to us for review and approval. We talked about one of those in our meeting last night on zoning, where there's a contract that related to that zoning. It was, I'm presuming it was drafted by staff or council or by our attorney, but I don't know. But if all the authority is in the city council, then the city council would have had to tell our city attorney to draft that contract. Here, we should be delegating a lot of this daily operations to the city manager. But the way it's written, it still leaves the city council with a lot of authority over, being able to direct the city attorney. Which is, I think, the point is, city council needs to have more input and authority.
All right, so,
we thought that was understood.
I'll read to you what's been changed and confirmed. And then I'll tell you why I'm not going to work.
Okay.
The city attorney shall serve as the legal advisor of the city council, represent the city in litigation and legal proceedings as directed by the city council or delegated by the city council to the city manager, review and provide opinions as requested by the city council on contracts, instruments, and ordinances and resolutions of the city and other city business, serve as legal advisor et cetera, et cetera, et cetera. So the language that I've added says that the city attorney will represent the city in litigation and legal proceedings as directed by the city council, was delegated by the city council to the city manager. Don't know how the city council will delegate to the city manager the representation of the city in litigation and legal proceedings. And I'm not quite sure, I'm explaining because it's not you, it's me.
I think in you articulating that, then the actual location of the, or as delegated city manager may be misplaced. Let me do this.
Let me see, here's a shortcut. How about not specifying the duties of the city attorney shall serve as a legal advisor, and legal representative to the city and city council, period.
Which is what you have.
Well, but we also have all these other caveats or these, the additional language that could be interpreted as limiting scope of.
I see what you're saying.
Yeah, so
That is a workaround, that I think is doable. The less you say, the more, the easier it is to not have.
Less is more.
Yeah.
Less is more.
Yeah, the more you say, the more you actually limit or bind. So
Can you read that again, Dave?
the city attorney shall serve as a legal advisor to the city council and to the city.
What about a caveat that says on all matters?
That's kind of implied though, isn't it?
Would that have prevented what happened the other night?
Okay, I think we could prevent that.
Well, no, there is something there.
Well, I know, right, but for every rule that we create would have second effects, unintended consequences that would next to happen. Trying to address a specific problem with a foundational principle. And it just doesn't. The more you try to do that, the harder it becomes.
Haven't we just opened the door for that option there?
Council's always had the ability to do something if they did. I may not like what they did or how they did it, but that doesn't mean that they don't have the ability to do it. Doesn't mean that a future council or a past council hadn't. It's just when there are other remedies for individual. There are other things that can be done to remedy unusual things like that. Let's just say unusual for lack of a better term. But I don't know how to put that kind of a limitation to address a specific discrete incident into a foundational document.
I guess maybe I'm suggesting that at a minimum, there be notice of any legal involvement that impacts the city. City manager ought to at least know about it.
City council shall appoint a competent, duly qualified, and licensed and practicing attorney, who shall serve as the city attorney. And we have a simple majority concept for appointment or just for removal. If you said the council has to appoint the attorney, that kind of implies that there's going to be public notice, and an open meeting. That makes sense.
Yeah, I'm not specifically talking about the hire and fire of the city or the city attorney. Talking about specifically what happened the other night.
Talking about stopping an outside attorney.
Yes.
Attorneys from getting involved, but if an attorney wants to get involved in something, no matter what you say, they're gonna get involved.
Look,
Right.
yeah, but if the council wants, and if the council wants to hire, special counsel for something specific, then I don't think it's a good idea to do something to limit them, or to specify the only areas in which special counsel could or can't be appointed. If we had, I don't know, we use outside counsel for bond counsel. We had a lawsuit involving Disney and franchise fees that was kind of a not class action, but multi-jurisdictional lawsuit where we retained the cities that participated, didn't pay for it, they retained an outside law firm to handle that one specific case and the mayor Butler. We participated in steering committees where a law firm in Austin, Lloyd Gosselin, will serve as a representative in the steering committee. So we use other lawyers regularly, and all cities do. You don't want to tell the city council that they can't do that because lo and behold, the day that they do, the day that you do, or the day that we do, something bad's gonna happen. And if it's something that's far beyond the expertise of your city attorney.
Yeah, I guess
that's,
I'm referring to not being blindsided, I'm referring to a notice. All of those cases you just suggested, none of those included blindsiding, all of those included. Right?
That's true. The
Where are we
reputation,
where are we at in our agenda in our
We're
meeting?
still-
Because I'm
we're
really
still-
confused. Are we having?
Right now, we're having, I asked for questions on the items that we wanted to straw poll. And so David brought up some revisions to, the section, the numbers 4, 5, 6 regarding the city attorney. And now Kevin's talking about potentially adding or looking at an opportunity to add language to ensure there's proper notice whenever there is outside,
Proposing new amendments.
additional language.
additional language to the, potentially here somewhere else regarding notice. So that way, when you say blindsided, you mean the constituents being blindsided with information?
Constituents, council, and our city attorney. All three.
But was council blindsided?
Somebody, I mean,
Some council members blindsided.
Yeah.
But they were supposed to,
I don't understand how an attorney could be hired.
and council not
Council
know
don't know
about it.
about it unless the city manager just hired that person. So do we know based in this scenario? Because city council has to have notice if they're going to authorize a contract unless it falls under the authority level of.
Maybe
city
that's why he
manager.
said you can't spend more than $50,000 because then it was under the city manager, you know.
So in that case,
threshold.
they can't, I don't believe, somebody's got, there's a lot of.
There's Elizabeth right there, ask her.
I
So,
know.
so was this attorney hired, David, to the extent, you know, by the city manager and some of the council members knew what was happening and some didn't? Cause that's kind of,
I can tell you with certainty that this outside attorney was hired lawfully and in accordance with our regulations. It was done correctly and it was a legal process. It may have not, it may have appeared to be unfair, but it was a lawful intention of outside counsel.
Because at this time, city council doesn't always have to approve any outside counsel, correct?
The city manager has discretionary spending authority.
Yeah,
He usually asks for ratification after the fact if it's
more.
added than or even for some things within that $50,000 spending.
you don't have to shake your head, yes, if it's okay, but certainly shake your head, no. Is that how this happened?
I can't answer that. But,
Well,
city manager was directed to.
Well, then how about we do this? How about we go through the straw poll for this section and we add homework to, I don't know if I can give us homework, or our city secretary to find out exactly what occurred as it relates to the hiring under, you know, just to figure that out. Because I think we need more information to even add any language related to,
Let me see if I can put you guys back on track. Again, trying to address a specific discrete issue with a charter amendment, or charter proposition is probably not the right way to go. Because it will have unintended consequences. The situation that happened may not ever happen again. And the rule that you create may restrict the ability of the council or staff to do things that they would otherwise need to do that are done in the open with those and all that kind of stuff. So I don't think it's advisable for you guys to be considering a charter proposition that is designed to address a specific incident. That makes sense?
I don't think it's the specific incident, it's the optics of it all. It wasn't the incident itself, it was the optics, and we cannot actually control the optics of it. Because if there are 3 people who are wanting something done, they can get it done, right? So that's not something we can address at
Yeah.
the charter,
Right, yeah.
right?
Yeah, the way you can address that is that amend the provisions in the form. Council can't make a decision except in an open meeting on an agenda that's been posted at least 3 business days in advance. In the law, the Open Meetings Act compels that decisions be made in the open.
Mhm.
Let me get my microphone. No, the Open Meetings Act is the guardrail. In theory and in practice. Decisions of the council cannot be made except in an open meeting.
So I agree with Stoll, we probably should vote on straw poll. I do find it troubling that this is open, this is not executive session material that you're not willing to, you're giving us such vague answers that would suggest it's legally protected information when all of the stuff is out in the open. But I say that, I want to stop and let's get on with business.
So what I'm gonna suggest is the draft language is there. At your next meeting, if we have a different proposal for an alternative language. That you guys present in such a form that it can be approved. Second, at the time, the number of meetings. It's short.
Okay. Do you have anything else regarding your questions on? Okay, okay. All right, so the next item is what we're gonna do is we're gonna straw poll items 1 through 6. With some of the changes that we just made to that section 4, 5, 6 related to city attorney. We're just gonna do a straw poll, hands up and down for each one, and then if there is no kind of, you know, super majority, then we will move forward and bring that back for an actual vote. So this is not an official vote, it's just kind of figuring out whether there's enough interest for us to keep moving forward with the discussion.
So we're starting at transit.
So we're starting at transit committee. So that's transit committee. This is related to, the language related to the transit committee that we want to make sure that we have in the charter for, before we do anything related to like DART, for example. And we know there's going to be
That page 8, right?
that is
Yes,
on page
correct.
8.
Yes.
Section 8.13, transit committee. Who's in favor of moving forward with this one?
We want to look at which version.
We're not going to do that yet.
Okay.
Who's looking forward? Huh? Okay, any opposition to this one? Okay, all right, looks like this one will move forward for official vote. It's not official, and then we can look at the actual language. Okay, number 2. At-large council member, adding a District 6 at-large with the concurrent cascading changes if this is an affirmative. Who wants to move forward with taking this for official vote? Anybody not in favor? Okay. All right, that one will move forward. Number 3, that's the unexpired term session. That was very simple, related to 2 years serving as a full term as member. Anybody want to move this one forward? Raise your hand. Any opposition? All right, that one will move forward. Okay. 4 is related to, actually, is it okay to do these all together? Because they're all related, they're all intertwined. So we'll do 4, 5, and 6 together. Who's in favor of moving forward, for vote for 4, 5, and 6, city attorney language? All right, any opposition? All right. All right, we're good. So it looks like we're gonna move forward with all of them. We'll bring that back, into the next meeting for a official vote. So review the language. If you see any changes, any additions, or would like to draft an alternative language like you did for transit, please feel free to do that. If you do put together some alternative language, if you can send that sooner rather than later, so that way we can incorporate it into the packet, Brooke. So that way we're not having to, we've already done our homework ahead of time before, and not having to look at it fresh and have, a discussion here. That way we have some background information to review before the meeting. So if we can do that sooner rather than later. And usually we get the packet a week before.
I think you by Thursday at the latest, the week prior.
Yeah.
So we would need to remember that.
So if we can get it by maybe within 3 weeks from now, in 3 weeks, that would give them enough time to prepare it for the next meeting.
Stacy, can you maybe send us a reminder a couple days ahead? If you're gonna give us some language.
Please give it to us by Friday and maybe send it on Monday. That's a good idea. Okay. All right. We are good there. Thank you for the homework. Hopefully we won't give you too much to do. Okay, so now we need to vote on C3, which are the proposed recommendations from last time. We only have 2. So, C3, this is page 12 in your packet.
Yeah.
All right, this is, the first proposal we had is for section 7.06. Add, replacing resident with residing. All right, this is an official vote. So all in favor of the amendment to section 7.06 for our charter to move forward to city council for consideration, raise your hand. Any opposition? All right.
You can say that's an official.
Sorry, I need to take an official motion. You're right, it's not a straw poll. Okay, I will take a motion to, section 7.06 amendments.
I have a question.
Yes,
Remind me, is this just a grammatical thing?
Yes.
To Say every person read
That,
that?
yeah.
Okay.
yes, it's just
The
grammatical.
red.
Yep. All right, I'll take a motion.
I make a motion.
I vote.
Brian seconds. All in favor, say aye. Any opposition? All right, so moved. All right, section 7.01. The city is divided into 5 districts known as districts 1, 2, 3, 4, and 5, period. Removing the last section.
Question, if we are gonna propose the at-large district,
We'll have to come back and make any changes to this one eventually if we do close that one. Yeah. So when we do that, we'll have to come back and see if we need to make any cascading changes based on things that we already voted on.
I think you said 7.01, you meant 0.10. Okay.
7.1.
Well, no, yeah, section 2, yeah. Yeah, section 7.10A. Okay, I will take a motion to approve and move this one forward. We have a motion, do I have a second? Second by Janet, all in favor, say aye. Any opposition? All right, so moved. Now, we're moving over to section C4, review and discuss and determine if amendments are needed for Article 8 and Article 9.
Chairman Thomas, just, on page 13, for this item, there are 3 items that are requested that are council-related questions. Just if you're reviewing these sections, and you can pose those questions as well as you review it. Just wanted to call that to your attention.
These are the ones that came from council, correct?
Yes,
Yeah. And we had which section they were in?
in these sections that you're doing.
Oh, we don't have an actual, like, okay, no, you're good. Okay, so. Did everybody get that? So number 1, 2, and 3 under discussion, those are the recommendations that, we received from council for review. So I'll go ahead and read through them before we go through each section. So consider requiring the capital improvement plan to be updated every 5 years instead of every 7 years. Discuss requiring the establishment of a specific page on the city's website where all bids and purchase orders, not just accepted bids, are posted for transparency. Consider clarifying the language regarding the reestablishment of a charter review committee and the appointment of its members. Okay. So we'll keep those in mind and we will go over section 8. Right. Section 8.01, powers of the city. Any concerns, central amendments for this one? Pretty self-explanatory. Okay. Hearing none, section 8.02, franchises use city property, power of council. And I think that was my question, was the 3 areas that, the 3 questions that were proposed by city council. Do we know which section they're on, they would be under if we do them?
It's not specifically in here, so we would have to designate them. Our attorney would have to.
Okay,
designate them.
sometimes, no, because sometimes we had like a
Yeah.
subsection that a potential amendment would be under, that's why I was asking.
Yeah.
Okay, but they would be under this section, got it. Okay, all right, so section 8.02, we don't see any, hearing none, section 8.03, franchise value not to be allowed. All right, moving that on to section 8.04, right of regulation. All right, section 8.05, consent of property owners. All right, 8.06, extensions. Section 8.07, temporary permits. Okay, section 8.08, other conditions. Great. Section 8.09, franchise record. Section 10, accounts of municipally owned utilities.
I guess water. Water tower. Water.
Then we go on a roll.
Section 8.11, relations of rate, I mean, what? Okay. Water. Okay. Okay. Section 8.11, relations of rates and services. All right, section 8.12, rate changes. Right?
Wow. Respond.
Yes.
Dave, this is Rick. Do you have any of these categories? Been issues at all?
In terms of franchise and those utilities?
There was any of them that we might want to take a little picture of?
State law usually controls the detailed matters, but these are generic to the neighboring provisions. Besides, we're going so long. Going one at a time. That silence is golden.
Well, like, no more, on section 8. Still section 9. Okay. Let's see. Section, our article 9, miscellaneous provisions. Section 901, no officer or employee to accept gifts, etc., from public utility. And none. Section 9.02, personal financial interest in contracts for sales to the city, disclosure violations. Section 9.03, church and school property not exempt from special assessments. Section 9.04, notice of damage or injury required.
I have a question on this.
Yes. Sorry.
How does that hold up in court? Deem
Section
yourself not liable?
Which one we don't?
9.04.
Page 17.
The city shall not be held liable if a person gets hurt based on defects unless they knew about it in advance.
So there's a whole body involved in the state of Texas.
Feels good to be the king.
Yeah.
There's sovereign immunity and there's limited waivers of sovereign immunity of which cities have to have certain knowledge of the conditions as opposed to constructive knowledge, which means they should have known. So there's a whole statute and tons of cases that say that unless you follow certain those provisions, you lose your right to pursue a claim against the city if you have them.
Other charters in other cities, 6 months is a good amount of time. A lot of them say 90 days. The last time I did one of these, I recommended 16. The commission said, no, let's make it 90.
I don't even know what you're talking about under 90. This says 24 hours advance notice. They have to know.
The city shall receive written verified notice as a condition precedent to the filing of a claim lawsuit.
So
6 months after the incident.
if somebody who doesn't live in the city and is not familiar with any of the traffic lights or anything, whatever, is walking down Rawhide Creek, and there's a retaining wall, which I noticed is starting to crumble, they're walking around there and it just crumples, maybe the city hadn't followed up on it, and he gets hurt, and he had his first time ever at Farmers Branch, and they say, sorry, you didn't have to go 24 hours in advance, if that retaining wall was unsafe.
I don't know where the 24 hours.
Find out code for, I might be looking at the whole version.
We're looking at the second paragraph.
City of Farmers Branch shall never be liable on any account of any damage or injury to person or personal property arising.
That's not a notice requirement. It says that the city manager of the city has to have actual knowledge of the condition prior to the injury. The notice requirement is 6 months. If that retaining wall falls on that, that's or they got 6 months to notice if it's like.
Yeah.
Okay. I'm seeing the thing, I might be looking at the version I printed before this. I printed this before we had these meetings, but it says they're not being held liable unless the defect causing the damage or injury shall have been actually known to the city manager at least 24 hours prior to the occurrence of the injury.
Right, if that means
It's like a storm, a storm.
in some circumstances, a city to be liable and to get around sovereign immunity, the political subdivision, because it applies to managing cities, has to have actual notice of a defect. Hypothetically, for example, there's a statute called recreational use statute. If somebody is in one of our parks and a tree branch falls on their head. And apparently that is not that uncommon. In order for the city to be liable, the city has to be grossly negligent. Gross negligence requires, among other things, that the city or the political subdivision have actual knowledge of the defect. You can't correct the defect unless you know about it. So that actual knowledge is one of the set of requirements for liability to attach. The charter provision doesn't override state law, but it's saying at least 24 hours beforehand.
I think, Brian, maybe an example was, is if something, a condition comes about just really recently, within 24 hours, the ability or the likelihood of the city manager knowing about it is slim. Give you an example. I'm going out on a limb, but I do that a lot in the job. I'm paid to figure out ways to find liability or create liability claims. Is this wall, where this retaining wall, that fell on somebody, didn't get the outdated condition because it was, nobody repaired it, nobody looked at it, nobody maintained it. It happened because a car went off the road, clipped it 18 hours before, and it's in an area that, you know, your normal city staff is not going to be there until maybe 24 hours. They come around every 2 weeks or every week. And so there's a condition that's likely not found in a very short period of time.
Okay, so am I interpreting this wrong then? So it's not saying, it's not like if someone gets hurt at my house, they can sue me, even if it's a criminal breaking into my home, he trips over a Lego, right? Now, the way I read this, if that were, my home were the city, someone would have had to tell the city, hey, there's a Lego on your floor and it might hurt somebody. And the city would have to have been notified of that dangerous scenario in order for them to be liable for any claims on someone hurting
So
themselves.
it's an easier example.
Okay, give,
A street defect, a pothole in the street.
okay,
You're driving down the road, there's a big pothole there. You drive into it, go out of control, your car spins. and you
Okay.
die.
okay,
And you're ever sued the city. State law is gonna override anything that might conflict in our charter, first of all.
right, okay,
But for special defects, the city has to have actual notice of that defect. Not 24 hours notice, so it can be, it's gotta be at some point prior to, and the law doesn't say 24 hours. But in order for the city to fix it and prevent that kind of injury from happening, the city, a political subdivision has to be aware of that defect. There has to be knowledge of the special defect. And so it doesn't, you aren't the one who has to give them that knowledge.
right, but it has to have been given to them. If the pothole is there for months,
The city has to know
nobody
about it.
officially told them.
No. If the city's done inspections and know that it's there, if somebody, called somebody on city staff and said, look, there's a big pothole, we gotta fix that. Any notice at all, it doesn't require that it be in writing, and it's gonna override, instead of overriding conflicting charter provisions, the city just has to have some knowledge of the defect.
Well, let's give the glow in the dark park as an example. If I have a little kid and they hurt themselves in that park.
Yep.
And it's, I don't know, the trampoline thing in the globe snap and he falls, right? But up until that day, it all seemed kosher, all seemed good, right?
Give you a better example.
Okay,
Water slide at a water park in a town, case where I was assigned to represent the city on, not Farmers Branch, different city. Water slide has a run out lane in it. It's for small children. All right, the run out lane was that wide, maybe 10 feet long. It had 10 inches of water in it because they capped the end with a piece of plexiglass. Literally 10 inches of water. 3-year-old girl drowns in that water slide. All right, city had no knowledge that that was a special defect. City is not liable for that. You understand what I'm saying?
yeah,
Somebody runs into a pothole, somebody walking down the sidewalk steps into a manhole that doesn't have a manhole cover. There are cases that talk about that. City had no idea and therefore no opportunity to correct. Right? This charter provision would be overridden by conflicting state law, and there are a number of different circumstances where state law would regard this as being inapplicable or invalid. But in a circumstance where the city has to have knowledge of some special defect for some condition, regardless of what the charter says, there has to be some knowledge before the city can be compelled to fix it. That makes sense. And if you own a piece of property and someone is trespassing on your property, with Lego on the floor, someone breaks into your house and steps on that Lego, you have to have knowledge that it's a dangerous condition. You can have to fix it. You understand what I'm saying? The standard of care is kind of similar to a trespasser for incidents that happen in public parks.
So like a design flaw wouldn't,
That's the manufacturer's one.
okay.
You know, in that case, the child that got in the water started, that makes just a difference. I felt bad about it, but no supervision there anyway. Well, yeah.
Okay,
All right.
Yeah, one more question.
yes. Oh, sorry, Kevin.
David, in 9.01, we identify public utilities. Why are they singled out? Are other organizations, corporate or otherwise, able to provide gifts to employees?
No question. That's a good question. I don't know that.
It seems to be written globally, just specific.
That sounds like it was written because of some specific scenario that happened, like,
Because of a particular incident.
because of the.
That was the foundation was changed in the charter. I can't explain why. I will say this, though, that apart from what the charter may say in subsequent sections dealing with financial interests and conflicts, our ordinances are pretty clear on that. So I don't know why public utility corporations are doing that. I have no clue. Good question. Don't know.
Thought not fire and delete.
How do we know? So what? Okay, so now we have Atmos and Encore are subject to special, I'm okay with that. I would agree with that. But it wouldn't matter if it were public utility, the private
I
corporation.
think just get rid of the whole second half of that sentence, right? They shouldn't get any gift, favor, privilege, or employment from
Any corporation joining.
public
Anybody.
or any, yeah.
Well, that might create a bit of a problem. I gotta work for somebody. I work for a corporation and at Christmas, they give me a bonus. Somebody gives me one of the managers gives me a bottle of wine. That's a gift. So
Okay.
you can get kind of,
Got the hard hat in my office for Builders to Hope on it.
right.
I didn't have to pay for it. I don't want to go to jail though.
David, could this be because of bids between companies that are, providing water, electricity, stuff like that, and to keep it from.
No, not with public utilities, there is no competition. Then with public buildings, there is no competition. My guess is going to be that there must have been a circumstance at some point in the past where a utility provider, which in theory has a lot more money.
Because it's implied that you could receive a gift from a non-public utility.
Well, there are public and there are private utilities.
You could get a gift from a private utility or private enterprise and doing your
Yeah.
duties as a city employee.
I didn't write this record, I'm not crazy about it, but I don't. It supplements a whole bunch of regulations and laws that are already out there. I mean, you'd rather prosecute somebody on chapter 171 of the government code than 9 foot of water for same charge. Much more effective, much more clear. And when we first started this process, one of my recommendations was to try to minimize the number of charter amendments that we're going to recommend. The more you recommend, the more fatigue voters you're going to get, or council, or Shannon. So As we get down towards the end, we've got a bunch already. I'm gonna suggest that, unless it's something that's problematic. Lots of stuff I'd like to change, but
I think there's state laws, like you said, that cover that stuff already.
Right.
we were on a.
So we were- We're at 9:05.
9:05, yeah.
Yep, section 9.05, city exempt from appeal bonds.
Well, it's just so anyway, but
Right, section 9.06, execution, garnishment, and assignment.
Constitution already exempts us for garnishment and execution, so it's a superfluous provision. Stay in there, no wrong with that.
Right, section 9.07, no lien on public property, contractors, et cetera, to notify city of claims.
That's also covered.
Yeah.
Did you say 907?
Like I
Yes.
said,
In the second line, what is material men? All subcontractors, material men, mechanics, and
For those who provide materials to a construction site. On the state,
those who provide materials.
materials, suppliers.
Brick, stone, roofing material,
Right, don't forget sheetrock.
paint,
lumber.
Which is material.
Yeah, it's used in different lines, so it's a really. But it goes.
I like that.
You eighties people.
I'm fitting all more categories.
Okay, material men stays. 9.08, bonds of contractors.
That's a good.
That's great, yeah, that's good. Section 9.09, condemnation of dangerous structures.
We have some limits to that,
Yeah.
and try to see if we're ready to hear that, so we're gonna check.
I have a question. Is there existing laws that give people who have had their buildings condemned any recourse for appeal or third-party verification?
Yes, there are cases and statutes. State law provides in two different provisions, section, chapter 214 and chapter 54. Are enabling statutes that authorize cities to adopt regulations that deal with the demolition and condemnation of substandard structures. And there is a fairly recent 5-10 years ago called Heather versus City of Dallas, a recent case that affirms that the process associated with demolition required, among other things, full complement of due process rights that include prior notice, public hearings, and an appeals process.
Okay,
Isn't that part of the minimum property standards?
I don't know what we call it.
Yeah.
There are a couple of different codes, uniform codes that are adopted. I think we have the International Property Maintenance Code, but I'm not sure.
Yeah, because the city of Dallas had, I mean, just, I still talk to people at DPD and some rather ratty apartment complexes just kind of disappeared under this because it's no electricity, everything is gone. There's still people having to live.
Yeah, I got another city. We just tore down $1 billion home in another city last week. That was substandard of condemned property. We get on track.
Yeah.
But yeah, no, we're good. We're good. Okay, you're right.
Section 9.10, building permit. Section 9.11, bonds to city official, employee, or department director. Section 9.12, when provisions take effect. Okay, so. Okay. There was an item for discussion from council. Just want to give you all a heads up. It says, consider clarifying the language regarding the reestablishment of a charter review committee and the appointment of its members. So some of these next ones are related to charters, so I just want y'all to keep that in mind. So section 9.12, when provisions take effect. That one's pretty self-explanatory. Section 913, right to amend the charter. Right, section 9.14, ordinances, rules, and relations validated. Section 9.15, severability clause. Section 9.16, nepotism.
I have a question.
Sure.
I know it's not gonna go anywhere, because it's kind of, I think we talked about it in a different capacity earlier, but I think this might, it's so strict, there ought to be some kind of carve out for just your minimum wage job worker, like your, you know, great nephew, teenager just going for a rec center job for the summer, lifeguard. It's a little unfair, but I know there's no way we can carve out any of these exceptions for silly little jobs like that. I'm not talking about like some political office, you know? Seems awfully strict.
State law that supersedes. In chapter 573 of the text of the code contains prohibitions and exceptions in circumstances in which anti-nepotism prohibitions would apply. I think this charter promise, this charter of language, this indicates that it was done first in 1971, but most recently in 2013. Was an effort to try to categorize every single person that may be within statutory nepotism prohibition. Really kind of reprints what state law already says, at least in subsection A. But it's a long drawn out, but I think this probably goes a little bit farther than what state law says. Like great nephew, I mean, like 3 degrees of consanguinity or affinity, not necessarily got that out of nephews. And that's a count, but that's like 4 or 5. Don't need to be that strict. There's no carve out for simple things like temporary employment, life credit, swimming pool.
It's what it is.
So Dave, you're thinking this is more, or I'm thinking of the second degree of consanguinity. It goes beyond that.
It only-
And with this, am I right, where it states the second degree of consanguinity?
I think it's 3 degrees of consanguinity or affinity.
3, okay.
This
This is pretty overreaching, I think, but,
it's kind of strict, isn't it?
Feels good.
it feels good. That's a good set of guardrails. But, you know, going back to what the image just said a minute ago, we need to minimize this, so. Already corrected.
Yeah, it's third,
All the problems we don't have.
under state law, it's 3rd degree by consanguinity, 2nd degree of affinity.
Okay.
And great nephew and great nieces are, and second cousins are way better. I don't even know what it's thinking of.
Can you share a grandfather?
Is that what it is?
I hear banjos.
Yeah, no.
Okay, moving on.
Thank you.
You're welcome.
Jason's happy with this one. I want to.
That's the way it is now. This is the way it is.
Yeah, it is.
Suggest.
Yeah, it's the way it is now, yeah. Okay, section 9.17, incompetency.
So broad interpretation.
It is,
Does it apply to the council?
technically.
At least it's a definition.
Oh, we didn't have those.
Not existing at the
It
time.
doesn't, I'm just kidding, I'm just kidding.
All right, well, you got it.
Okay. Section 9.18, official misconduct.
Another definition.
Believe me wrong. Absolutely.
I'm sure that you all. Hey,
Okay,
Can we ask a question?
yes, of course.
Just real quickly back to 9.15.
No, we already went through that. Go ahead, no, go ahead.
Isn't there maybe a perfectly great reason for this, but I'm a little confused?
No, go ahead.
If any section or part of a section, it says a section 3 places, but the A has brackets around it. Must it have brackets? Is that a?
That looks to me like it's an editorial mark.
It doesn't seem like it fits, but it could, and I may just not.
The brackets are editorial in nature. I think maybe somebody at some point, and I don't know who, the section must have originally read if any section or part of section of this charter shall be. And I think somebody made an editorial comment by putting the letter A in there in brackets to correct the grammatical mistake. That's just a guess.
So does it seem like it needs to be there? That the brackets need to be there?
Yeah, the brackets don't need to be there, but I think brackets are only there, like I said, as kind of like an editorial rules. Then somebody reading it would know that the original has to
Talking about the drafted A's in section 1.
But it correctly, grammatically correctly, it should not have the brackets around the left page.
No.
But
But isn't that such a minor thing? Should we really put that?
that's what I'm saying. I don't think we should, that's, it's less than that.
She said there was a reasoning behind it.
I will tell you, if it's
It
not
made
lit,
perfect sense.
every time it's going to be brought up. Every single charter review.
But if we have the provision that grammatical and spelling errors can be fixed, then.
We're on 9.19.
Thank you. No, thank you, Janet. Yep.
We're on 9.21.
No, we're 9.9, indemnification of officials and employees. All right, section 920,
I've got the first sentence,
for which
the
one?
city, in 9.20,
Okay, 920, okay.
the city council shall be beginning in 2028 thereafter.
Yeah, I had a question about that too.
That's probably a typo, right? Or
I think there should be a comma between shall and be.
Yes, exactly.
The city council shall, comma, beginning in 2028, comma, and therefore appoint, but that still doesn't make sense.
so why?
Well, take out the comma after the 8 in 2008 because then it works. The city council shall have comma beginning in 2028 and thereafter, comma, 2020. That works. I think that's.
Yeah, so we're moving the comma after 2020.
Why is 2028 in there?
Yeah.
That was the question.
That was my question. I missed the grammar part. I just thought of 2028.
I can add some clarity, when we went through a charter adoption several years ago, this was changed, this language was changed at that time. And so they wanted to have it starting in a particular year, and so that's.
Well, why did they pick 2028?
It was 5 years since the initial adoption, when it was voted upon.
So this is a, yes,
This was written in
So-
2023.
yes. So this charter committee, my understanding is that there were enough votes to do, because according to the section, it can be,
2 years.
the charter may be amended no more than once every 2 years. And so the city council decided to bring a committee together to look at amending the charter in between that 5-year mark, which they're allowed to do because they did it in its after its second year. Or its third year rather. So,
Yeah, but charter proposition was adopted on June 4th, 2024 by ordinance that you and I signed. But I have absolutely no independent recollection.
Maybe just remove that beginning in 2028 and thereafter. Because if we leave it in here like this, we're gonna have to have another charter review committee in 2 years.
I mean, but technically you do, because we have to have one every 5 years by the charter.
Okay, well, we have one, this is 2026.
And so my understanding is that you're allowed to amend it no less than every 2 years, but then every 5 years you still have to call for charter. At least that's my interpretation.
And the city.
No, we do. So the voters do. So every 5 years, there has to be a charter review committee and there has to be, if there's any findings, there has to be approved by council. It has to go for voters for official amendment of the charter. That has to happen every 5 years. And according to also the charter, you actually can call an ad hoc charter review committee to review it as long as it's no less than 2 years in between within those 5 years. That's my understanding.
That sounds good to me.
And the ad hoc committee would just consider the one thing, or would they?
No, they do anything, but they asked us to do all of it.
That's not.
Oh, the same group.
This is us,
How long
yeah.
is our appointment?
What?
How long is our?
No, just for the purposes of the city council decided to vote on an ad hoc committee to review the entire charter, and that's when we came into existence.
So we're an ad hoc.
We're the ad hoc in between these 5 years,
2 years again.
One and done.
which we may, or then at that point, the council's gonna make other appointments, and maybe us, and may not, but they'll appoint a new charter review committee for the official 5-year charter review that's mandated by the charter.
I think some city employees, it's like having leftover food and everything.
No, I think there was enough,
That's not bad. That's like,
so there was enough discussion on a lot of these, because you saw the list from city council, but they had a lot of different things that they wanted to consider, and that's when they decided, okay, well, let's bring the charter review back to consider all of these different things for our approval.
So I think what we intended on this one is, it's starting in 2028.
Oh, yeah.
It's every 5 years, you have to do it at least once every 5 years. It wasn't that, starting in 2028, you point a charter review, and then at least every 5 years, this triggers in that 5-year maximum, starts in 2028.
So it's like a rotation from.
So,
okay.
whatever, I guess, okay.
So we will take the comment out of that, but again, if we do that provision with punctuation, we may not have to.
I have a question.
Yes.
Also about 9.2.
Yes,
It's the second to last sentence. The city council shall select the chairperson for the committee. If we selected our own chairperson. That's correct.
They defer to us, is what I understood.
Well, why do we want to say they did?
I thought that every nomination went to them and they had to approve it.
they did. That's for their appointment, but this is but I think this is starting in 2028.
Oh, okay.
Okay.
The council typically elects the chair. They chose to allow the committee to elect the chair at this time.
So it's okay the way it is.
That's how it's.
Yeah.
Okay.
What was it that they wanted us to do?
That thing that they sent us, we had that at the very beginning of
Yeah, I
our.
know, they said consider clarifying the language regarding.
Oh, yes,
What,
we'll
what
get to that.
language is it?
Yeah, we'll get to that. So that is something that, that we need to discuss during this section.
So you know what it is, sir.
No.
I mean, it looks pretty clear to me. Maybe I didn't like that comment.
Come back.
Okay.
Maybe that-
Okay, so nothing else on 9.2, 9.21, charter renumbering. Pretty self-explanatory. Okay, so there were 3 things that, were on the list for consideration. And so we'll go through those. Number 1, this is page 13, under discussion. Consider requiring the capital improvement plan to be updated every 5 years instead of every 7 years.
Discuss it.
No, it's not. I think it's an area where they wanted us to discuss it. We need to discuss it before we end our time together. And then if we decide to move forward, then we would have the city attorney kind of help us figure out which section that would be in, if we decided to move forward with it.
So where
Potential new section.
And so we don't need to know what section, I don't think we need to know what section it is right now. But I think we just need to discuss, is that something that we'd want to consider for voting for next time?
So where does a 5-year term already come then?
The 5-year term, what do you mean? Right now we have to look at the capital improvement plan every 7 years.
Yes.
So they're asking for us to change it to 5.
Where's the 7 years up here in what's that city documentation?
Page 13.
So.
So that's. What's not which section?
Oh.
It's not part of the charter that I understand. I don't remember seeing it.
I bet it's probably an ordinance.
I think it's probably a procedure because we didn't see it in the charter. And so I think they're asking for us to add it to the charter, similar to how we're adding the transit committee, where we're asking for there to be a review of a transit committee review.
Can't they change it themselves?
Yeah.
I think they're wanting to make sure that it's in the charter.
So
And that's up to us or not.
What's in a capital improvement plan, besides thing?
So that's when we look at like roads, we look at infrastructure, the major capital improvements that are needed by the city.
But theoretically, whether it's 5 years or 7 years, you could have a capital improvement plan and an entire council and mayor would have no say in it because you're updating it beyond their terms. I mean, their terms are only 3 years. They're not gonna touch the capital improvement plan. I mean, they don't all, some of them will say, don't have overlapping terms.
I
You
think we need some homework.
Yeah.
know what I'm saying? Like, I'm a mayor, I get 3 years. 3 of my council members just got elected, they get 3 years, they're never gonna touch the Capitol.
And that's also, well, I mean, you can look at the cap, you can add things, you can add things and you can, take things out. I think it's just making sure that every 5 years, you have to look at it, right? But I will tell you that, I mean, as those that serve, like, we look at this all the time. And looking at what do we need to add, what do we need to include and things like that. Doesn't mean we can't talk about it. It just
So we
means
get
that.
updated regularly.
That's my understanding.
I'm over here going, I'm not exactly sure what we're talking about, capital improvement plan. So I think we need, that's why I said we need homework, is tell us where this is, what it is, where it appears, is it, because in the budget, there's capital improvement projects. Yeah, so is there because I don't remember specifically a capital improvement plan.
That was never mentioned in the charter.
Yeah, and I don't know that it's specifically referenced in any city ordinance, but in the budget, there's capital improvement projects and there's kind of a amorphous, hey, we'd like to make sure we do certain things in a certain time frame, but where is it? So we know where, we need a beginning point. Right. So the homework for probably, staff, somebody tell us where we start looking.
So maybe send us the current capital improvement plan. Where is there any provision where is the provision that states that we have to look at it every 7 years? And if there's any background information that can be shared.
Right. I really hate to say this. I don't believe, I could be wrong, I don't believe that the charter contains any provisions regarding the adoption of the capital improvements plan. It does stay a lot for that matter. It's a bit odd to be considering a charter provision that would require that it be updated on a rotating basis when the charter doesn't even require that one exists in first place.
Well, that's kind of my point is how do we
Yeah.
know to start and why should we think, we need to know more to see and figure out whether it should go in here, because I don't think it should.
That's
But like a starting
City
point.
manager.
Well, it's not just city manager, but the capital improvements plan, really is a comprehensive document that talks about the maintenance and upgrading of all existing city-owned infrastructure. It's a long-range planning document, and it's kind of the responsibility of the council and city management to make sure that it gets updated and changes appropriately.
So this bullet point implies that it's in the charter. And it says every 7 years, and if it's not in the charter, it doesn't say every 7 years in the charter, then wherever the heck it is, and whoever it is that wants it every 5 years.
It may not be, it may not be in the charter, because if you remember, there've been a lot of requests that have been made that technically were procedures, and we decided to keep them under procedures and not add them to the charter.
Right.
And so I think this is one where we just need, to David's point, I think we just need a little more information to figure out if it's even something we should consider to be in the charter, or if it's in, if it's a procedure, keeping it there, and then just advising council. I think this is something that you all should,
Make it an ordinance.
make an ordinance or make an amendment to the ordinance where it currently resides to make it 5 years.
I did, by the way, find out what the reference was to the charter commission recommendation for, a council member had asked that you consider clarifying the language regarding the Charter Review Commission provisions and the appointment of members, specifically reviewing the language of 9.20 and consider that each member of the council gets to select 2 or 1 from each district or reduce the size of the commission.
Okay, so can you repeat that? So we do have some background information on that question number 3, which is, can you repeat that?
Review the language of 9.20, consider that each member selects 2 or 1 from each district, or reduce the size of the commission.
So right now, the committee shall consist of at least 13 members, with at least 2 members appointed by each city council district, and up to at least 2 members nominated by mayor. So right now, the each council district can get 2, and the mayor can get 2. And what you're saying, can you go back to it?
It's our final language. Consider that each member of the council gets to select 2 members or 1 member of the commission for each district, or to reduce the size of the commission.
So right now, it's or. So right now, it is selecting 2 members.
It's at least 2 members.
Or 1 from each district.
So basically reducing the size, but so basically, a council member can select 5 if they wanted to. Got it.
Yeah, because it says it'd be 13.
As long as we can see the front.
We've certainly had atrophy already in this group, so it's good to think that we have extra.
So then, yeah, I mean, and we do have people that have to jump off for whatever reason. So in this case, if we do right now, if we make that change, potentially, it would be 2 members from each district, which would, and then 2 members for the mayor, which would then be 12.
Unless we change the number of members in the district.
Unless, and I mean, that'll be something that we'll have to do.
What's the benefit of making a change? It's always been up to the discretion of the council. Some council members want to go 0.3.
So I guess now that I look at that really closely, it's not saying each council member gets to pick somebody from the district. It's just 2 from the district. And so, Elizabeth and in the power of 3 could, go and pick all the members from all the other districts, and the 2 of the districts wouldn't get to pick their own, 2 representatives wouldn't get to pick their own representatives. So I think the clarification will needs to be that each council member gets to appoint 2 people from their own district, if we want to make it that.
That certainly feels right, seems right. Right, the council people want to be able to pick their own people.
Was everybody here
But
reached
right
out to by a council member?
But right
Yeah.
now, the way it is though, you can, like right now, like if I was on council, I could select 2 people from, you know, let's say for example, District 1, or I could select someone from District 1 and someone from District 3, as it stands right now.
Right, well, as it stands now, the way you read it, if you read it closely, is if 3 council members join together and they all agree on all the members, they can pick members in the other 2 districts without any input from those other 2 council members. So I think what was intended is each council member should be picking members from their district. So they get to pick who could be there. And they feel like they're going to represent the district in the same way or similar to what the council members would do.
No, I get what you're saying, but right now it doesn't, like even if 3 council members pick people from one district, the other council members can still pick people from whatever district they want.
That's what happened to me.
Yeah.
There was horse trading. My council
There
member
was horse
picked
trading.
someone else, so that council member reached out to me.
There was horse trading, and that's good. But the way this is written, if 3 decide to get together, they can ramrod through all, 10 of the members. Cause they get to
No,
pick 2.
but it says at least 13. You don't have to have a maximum of 13. It's at least 13.
At least.
Yeah,
But 3 can coalesce and run the decision on 5 districts. Cause it doesn't say each council member gets to pick them for their district. It says.
No, they just pick 2. They just pick 2.
It doesn't say that each council member picks 2 at all. It should say that each council member should pick 2 people.
That's my point. It should say that, but it doesn't say that. That's why the power of 3 could control
it should be
the
rewritten.
10 members.
But it says at least 2 members are appointed from each city council district.
It doesn't say the district council member making the pick.
It doesn't say the council member gets to pick them exclusively. That's what I'm saying, 3 council members could coalesce and run the selection of 10 of the up to 13 members.
So are you saying each council member should pick 2 and they have to be from that council member's district? Or each council member should pick
Well, they
2?
want that anyway.
I just think each council member should pick 2.
You don't think it needs to be from their district though? It can be just any 2 people in the city.
So I think that historically in other cities, it's just been each council member can pick 2. Because what if, for example, I'm in a district that I want to pick 2, but I ask 10 people and none of them are able to do it, then maybe I only have 1, but I only get 2 and they have to be from my district. Or maybe I know someone that lives a block away that would be amazing and they're available and want to do it. And so then I wouldn't want to put a council member 2 in a box, in a place where now they're pigeonholed to just be able to do 1 because there isn't anybody else in their district that's willing to do it.
Get it?
And so that's why I would say, I agree. I think, I get what you're saying. I think every council member should get to a point 2. So it's at their discretion and the mayor gets to, but not necessarily say it has to be from that district. Ideally, you would think they would.
Yeah.
And honestly, people would say, well, why didn't you choose? Now, if I came and said, I tried 10 people and none of them want to do it, I would want to put someone in that situation. That's why I would say just that district and see how it goes.
Didn't we start off with about 23 members? The first meeting?
We did. Yeah,
Well, how did that, I thought it was supposed to be.
At least.
13 at least.
At
we did at least 13.
At least.
At least, not only.
More than that.
Not-
Well, the other thing too is if we do that, we also have to obviously amend that number, right? If we say at least two, or we say 2 members from each district,
Including 2 members from interest.
yeah, or maybe we just, I think the request is to put 2 or less, right? The request is from the council members to do 2 or less, but maybe we just do at least 2 members nominated by each council member as opposed to by each district.
Sounds fine.
And then we start there. Is everybody okay with it? So then we'll have that language. So homework.
I know.
So, now we got to 23 people for this committee.
Because that's at least 2. So there are probably certain, the council members probably said, oh, I want to, have 5 names that I want to give you.
So the council just chose one,
Yeah,
which is more than.
because they're able to, yeah.
Okay.
And somebody probably said, there is a lot of attrition, it's a lot of work, and so that's.
Which honestly, it makes, we have lost some people.
Well, I think then each council member should have an equal number of choices. If you can make it more than 13, you can make it 20, it shouldn't be someone from District 2 choosing 5 and every other district.
That's what I mean. So every district, every council, so I think what we're talking about is I'm changing the language to where every council member gets
Gets
to
to choose
appoint
at least 2
at least
people from
2
their.
people.
Yeah,
Not
But
necessarily from their district,
at
they can
least,
choose,
meaning that they can choose more, right?
they can choose more.
And would that mean that one council member would choose 4 and another would choose just 2? What I'm saying is,
Now you're showing the flaws of the like.
well, I'm just trying to find unintended consequences.
I know, you're doing a good
having
job.
a court.
The House versus the Senate. How about just pick the portion?
Or we can also say at least 2, no more than 4. I'm just trying to figure out.
Or simply appoint 3, not nominate 3, but appoint 3.
Up to
So
3.
that the others can't veto that.
That'd be 5.
15, 18 with the mayor.
I just want it so no council member should be able to choose
10,
more
And then,
than
yeah,
everyone else has the opportunity to choose.
so let's do that. How about this? How about we do up to 3? And then we look at that language and then we're gonna bring it up next time anyways. And then if anybody has an amendment to that, then we can discuss it then for vote. We can say up to 3. Every city council member can choose up to 3 individuals. Okay. All right, so, so now let's go back. So we're doing homework, going back to number 1, we're getting homework on capital improvement. We already discussed number 3. Number 2, discuss requiring the establishment of a specific page on the city's website where all bids and purchase orders, not just accepted bids, are posted for transparency. I think we need to figure out, is this a procedure? Are there any current provisions that, and where are they related to the website? It seems to me that right now, bids are required, accepted bids are required, but not all bids. So if we can just get some language, like some intel as to what ordinance, what procedure there is that speaks to this, so that way we can see if that's something that needs to be added to the charter. Is everybody okay with that? Okay. Yes,
I have one more thing about charter review committee.
Yeah.
It doesn't say that the members have to be residents of the city. Are we all residents of the city?
to be on I think the boards and commissions rules state that you do.
Okay.
Yeah, so that's already a given. So, yeah. Okay, that was a good question. All right, so now we are in section C5. Thank you all so much for your work on this. Charter review committee's opportunity to request future discussion on items not listed on the agenda. Anything that we want to make sure to include?
Motion to adjourn.
Not yet. I have 2 things.
Yes, very much.
Not yet, but as soon as we do, Brian, 2 things.
Right.
One, I wanted to let you know that Dan,
Yeah, I got it. So, thank you.
that Dan had to resign. He had a work commitment that is now on Wednesday nights. So he really wanted to be a part of this. He sent me a message. But unfortunately, his work, commitment now, is at the same time. Wanted to let you know that. And then, for our city staff, can you just give us a rundown of the meetings that we have left and the procedures moving forward so that way we're all on the same page really
Yeah.
quickly?
Yes, so that's something I was actually gonna talk to you about. So we have 2 articles left that we're gonna be discussing at our next meeting. 10 and 11, that will finish all the articles. But we obviously do have a lot of items to, cover and vote on next time. And then I'm finalizing the spreadsheet of all the amendments that you have requested so far, so I don't know if we're gonna be able to fit all that in at the next meeting, and do we wanna call a special call meeting?
So I think what we did is we left a buffer month
Mhm.
for us to have in case we need it. So I think my recommendation, if everybody's in accordance with it, is that we review the articles next time. We go over the homework, just like we did today, and then we use then we go over, at least just share all of the different articles, review that, not for vote, right, for any other discussion, review all of them. And then come back in October to see if there are any questions, comments, concerns, additions, anything like that. And the good thing is that we've been voting on them already, so it will really just be kind of just, juggling our memory a little bit about what we did vote on. And so I don't want us to go into, so I think having the articles next month finalized, I think would be great. So that way we have to do our homework and due diligence to go back and kind of refamiliarize ourselves with some of the things that we did, because what we don't want to do is open up a whole, conversation on an article we already voted on if we already had that discussion. So if you do have any questions about it, the good thing is that all the recordings are online. So I would just go back and all of the articles are in the agendas. So if you do have any questions about this discussion, just go back to that article and that video to familiarize yourself with what was discussed. Because October is the last meeting before we have to bring this forth to city council.
So no voting next time.
So next time, we're gonna be voting on the things that we talked about.
That's what I was thinking.
Yeah, no.
I said, no.
Well, no, I mean, like, we're not gonna be re-voting on those things that we voted on already. We will be voting, next time we're gonna be a regular meeting, just like we have today. And then in the October meeting, we'll be voting on the items that are, gonna be discussed from the article that we'll be discussing next time. And then we're also gonna be going over all of the articles that we actually voted on. So the October meeting is, I think it needs to happen, and we'll go over just one more time, all the different items that we already voted on for council.
A lot of votes this next time.
Yes, yes. So remember, this next time is gonna be all of those provisions that are in city attorney's handlers for consideration
When we
for
submit,
homework.
when we submit the list of recommendations, do they come with explanation as to what we mean? What's behind the change for each and every?
Yeah, so there's an Excel spreadsheet and it talks about each section and then it kind of says what the change was. And it says a little bit about the discussion from my understanding for what we've been looking at. So that's something that's new this year because we wanted to make sure we understood like, why did we say this? What was the discussion? But like I said, if you want to go deeper from a discussion we had, 6 months ago, I would just look at the videos to kind of jog your memory a little bit.
You intend to also present this to council with each of.
So then the next step after that is that I will be presenting all of the recommendations to council for consideration and then they'll take it from there. So I will be on an agenda, we will be on an agenda item and I'll be representing the committee and giving the recommendations. Awesome, great.
I'd like to know the date of that meeting.
Yes, we will. We'll send all of that. Yes, we will want all of our charter review members to attend that meeting. So, yeah,
Clarify the minutes that we adjourned at 7:48.
perfect. So now one last item. We do need to approve the minutes with the amendment of 7:48. So, do I have a motion to approve the minutes? I have a motion with the amendment. Second, all in favor?
Aye.
Say aye. Any opposition? All right, move to adjourn. Do I have a second? All in favor, say aye.
Aye.
Any opposed? So moved. Thank you all so much.
Thank you.
Thank you, sir.
Thanks.